We're going to talk about the Unified Patent Court. We have Tobias Wuttke here, and Tobias is from Bardehle Pagenberg. He's been on this stage many times, and over the years, become a good friend. I appreciate you being here, Tobias, and good to see you. And you're going to bring us up to speed with respect to what's going on in the UPC, and maybe the first relevant question that you can ask. And before I even say that, if anybody has any questions at any point in time, please just raise your hand so we can make this a useful presentation for you. But what is it that you want everybody to understand, American companies, American innovators, to understand about the UPC? Is the UPC for them too, you think?
Yes. Thank you, Gene, for the kind introduction. And the UPC is the European Unified Patent Court. But that's a misleading concept because it's super relevant for US companies. They are at both sides of the V at the UPC. And they are among the top 3 when it comes to the most active plaintiffs, but also amongst the top 3 when it comes to the country where the most defendants are domiciled. So the UPC is a reality, and you need to wake up to that reality.
So, and I should have said when I introduced you, I failed to. You and your firm handle a significant number of these cases, and 20% of UPC. It's hard to believe, but 20% of UPC filings, your firm is involved in.
That's correct. We were kind of the early adopters since the start, when it started on June 1st, 2023. And since then, we gained a lot of experience before that new court, and also a lot of lessons learned, a steep learning curve, a lot of sleepless nights.
Mm-hmm. And I know your firm, because we just did a program on this, just got the first permanent injunction issued by that was finalized, right? It survived appeal, so injunctions are real at the UPC.
It was the first final injunction, a permanent injunction issued by the Court of Appeal in the Phillips versus Belkin matter. And what was really surprising to us, you know, when the new court started, a lot of promises were made to the user community. High quality, fast. Well, they kept the promise. It was an injunction issued within 2 years and a few months after we filed the complaint. And it's a final injunction of the second instance, both infringement and invalidity decided. I think that's exceptional. If you compare that to the global patent litigation landscape, they really delivered.
Yeah. And it's not just in the telecommunications area like it was in that SAP case. There are life sciences cases going on in the UPC today.
Yes. First of all, the first PI that was awarded by the UPC based on a unitary patent, that new type of patent that we have, was in the life sciences field. And apart from that, we see all type of pharma and life sciences litigation cases now at the UPC. SPC cases, innovator versus innovator, antibodies, small molecules, formulation patents, just everything. Second medical use, everything. Mm-hmm. And I think that's an observation, another surprise to us. We as a firm thought, okay, it will take time until this court is accepted by our clients. But now when we have a client meeting, it's no longer the question, why using the UPC? It's why not using the UPC? And why, in addition to UPC proceedings, we can also use the German national courts or the other European national courts. You know, we have this transitional period of 7 years where, based on an existing European bundle patent, you can litigate that before the Unified Patent Court or the national courts. So that's a really complex litigation system. And now the new trend is hybrid litigation, UPC plus national litigation.
In Germany?
In Germany, but also in other jurisdictions, in particular in the pharma sphere.
But Germany is it fair to say Germany is sort of the main the main partner with the UPC, and that you'll bring cases in Germany and at the UPC with some frequency?
Absolutely. I mean, we do that regularly, and Germany accounted for 70% of the national patent litigation in Europe before the UPC entered into effect, and that's still the case today.
Yeah. So, and I think that's important to understand, because I don't think a lot of us thought it was going to be either or, I thought. And it turns out that it's both.
It's definitely both, and that makes the defense really complicated. And when you hear about 2.5 years from service of the complaint until a final injunction by the second instance, the Court of Appeal, and we have no third instance, right? What does that mean in practice? That means you have a very tight deadline regime. And that means you as a defendant, if you don't anticipate that something is coming, you are caught by surprise. And you have 3 months to prepare your statement of defense and to file a counterclaim for invalidity. Find the prior art, find the experts. That's super tight timeline. Imagine there are some summer holidays in between. That really means you need partners. You would waste time if you were then to run conflict checks once such a complaint is filed and served on you. You need to be prepared, and so. But that applies both to the defendant and the plaintiff. Yeah? The plaintiff has the big advantage that he can take his time to carefully prepare the case and then file it. But with the counterclaim of invalidity, then the plaintiff, which is then the nullity defendant, of course, like in the US, same system, has 2 months to defend the counterclaim for invalidity and to bring what we call auxiliary requests. That means defending the patent as granted in a limited form. And that's, I think, the biggest difference between our patent systems. In Europe, you can narrow the granted claims with paragraphs of the spec. So you could say the paragraphs of the spec are kind of subclaims, dependent claims. Yeah? That is not allowed in your system, but it is in ours, and that is kind of the standard outcome. Yeah? The lion's share of the cases, here these auxiliary requests are the game changer, or the win it or lose it part of the case.
Mm. Now, you've been for a number of years recognized, not just me saying this, you were recognized as one of the top patent litigators in Germany.
Thank you for saying
right,
it.
But
Gene.
you know it's true. You know it's true. And I want you to know, because I want you to compare, if you will, German patent litigation with litigation at the UPC. So you are an expert, well-established expert in German patent litigation. Is it very similar to German patent litigation? Is it different? Where is it different? What should a U.S. citizens expect? Okay. And companies, not just individuals.
So the main difference is the UPC is a front-loaded system. And front-loaded means front-loaded means front-loaded. Every argument and fact and evidence and expert which you haven't brought at the first possible moment in time in the course of the proceedings faces a high risk that it will be dismissed as late filed. And this is a huge risk. And this applies also to these auxiliary requests I just mentioned. If the patentee, after some months of thought, thinks, oh, this would be a nice fallback position, I add paragraph 23 to my claim 1 and present that to the court. In the second round, you need a good reason why you couldn't have brought that already in the first round after when you had this 2 months deadline to reply to the counterclaim for invalidity. And it's a very strict case law and approach of the UPC on late filed arguments. It's my personal view, but that's how it is. It's a bit too strict and rigorous in my view, because you can lose the patent by just having brought a request a few months too late. Even so, you could say the defendant still had several months until the oral hearing to prepare his arguments to defend that auxiliary request. But okay, that's my personal view. It is like it is, and you have to deal with it. And we have to deal with it, and it means you need to prepare. Mm-hmm. And in Germany, that's different. You can bring in the second round of the briefings new facts, new evidence. It will not be dismissed at late filed. And so you can say that's one difference. Second biggest difference is in Germany, we still have this bifurcated system. That means the infringement courts only look into the infringement and not into the invalidity. Invalidity is tried before the Federal German Patent Court, so it's a separate court, and both are interrelated by this request to stay the infringement proceedings in light of that pending nullity suit. And the stay figures are still low. About 20% of the cases are stayed. That means in 80% of the cases in Germany, you get an infringement decision, a judgment, without invalidity having been reviewed by the Federal Patents Court. That's different at the UPC, and so far you could say the UPC judgment has a higher authority because infringement and invalidity was reviewed.
Yeah. So I want to pivot and compare this to the U.S. a bit, but before we get to there, let me ask you, does the UPC, in your opinion, increase settlement? And because it seems to me like it does, and it also seems like when we've talked about this, that patent litigation is a global, is an international game, and you file in different jurisdictions for different reasons, and as the patent owner, you can lay your plans in advance, knowing, and then really ratchet up the pressure. Whether maybe you file in the U.S. in an ITC, you file at the UPC, you file in Germany. Maybe if you have patents in South America and Brazil, you can file in South America, and you bring a lot of pressure to bear. The UPC, the speed that we're talking about, seems consistent with the speed at the ITC, and that whole thing would seem to create much more pressure on defendants to settle. Is that happening?
Yeah, that's what we see. And so the territory of the UPC means 18 EU countries. But we now have a case law since February this year from the Court of Justice of the European Union in BSH versus Electrolux, saying if you sue a defendant at his national court where he's domiciled, and imagine this domicile is within these 18 UPC countries, you can even get an injunction before the UPC for 39 countries of the European Patent Convention because the UPC is competent for European patents. That means a UPC injunction can, and we see this now happening in particular in your industry, cover more than the 18 UPC countries. That's point one. So that's a huge impact. Point two, what we've seen after a bit over 2 years now is in 80% and even over 80% of the first instance decisions on the merits, the decision was enforceable without the need to provide a bond, no bond requirement. This is a huge leverage in the hand of the patentee. No bond requirement. Of course, there's liability if you were to enforce such a judgment. It was later on overturned by the Court of Appeal. Then you are liable for damages. Clear. But still, no bond requirement. That means in the system where we have, as of today, de facto an automatic injunction, you have a first instance decision which allows you to take a product off the market. And in addition thereto, we have a system which grants preliminary injunctions. The UPC grants many preliminary injunctions, also in particular in life science and pharma sphere. So that means really this system drives settlements. Yes.
Yeah. So what are the key differences between the U.S. system and the UPC?
So first, the commonality. Proceedings are now in English before the UPC. The majority of the proceedings are in English. That's important. Okay, then you get injunctive relief also in situations where we don't have a competing or competitor situation, and also NPEs are entitled to injunctive relief before the UPC. Of course, there are also proportionality considerations that will play a role, in particular in the pharma sphere, which would mean there could be a use-up period, a transitional period for a patient group to migrate from one drug to another. That I can foresee, but as of today, no injunction in proceedings on the merits was kind of watered down by these proportionality considerations. So that is a major difference. And of course, we have no discovery. Yeah, the discovery is still very limited. So what we see a lot is now that US 1782 proceedings are used. You know, your discovery for proceedings in a foreign tribunal. So that goes hand in hand now in many cases. Damage awards, that's a big question mark because there is not a single damage award for the time being of the UPC. And I do not anticipate that we see US-style damage awards. But we see damage awards that are much higher than what we are used to in the past from the national courts, because the UPC is a one-stop shop system for damages. It covers, by logic, these 18 countries or even up to 39 countries in these situations where the defendant is sued at his domicile.
So let me go back to that, because I am thinking, I know because we had this conversation recently ourselves, but the first time I heard you say that, I thought to myself, that's going to surprise a lot of American attorneys, where I can get an injunction at the UPC and I could enforce it, for example, in the United Kingdom. Because if the company I get the injunction against is in one of the 18 member countries that the UPC covers, and then they also have offices in a European country that is not a member of the UPC, the injunction would apply to where they're sitting in those non-UPC countries based on a UPC injunction. And when I heard that, I thought to myself, well, that's going to strike a lot of U.S. folks as, I think, inappropriate or just foreign concept. But that's what is happening, right?
That's a big discussion, and it means Brexit. There is no Brexit. The UPC, or not the UPC, the Court of Justice of the European Union, with that ruling from February this year, has undone Brexit. Yeah? And that was certainly a surprise for the colleagues from the UK. And we have already the first UPC injunction for the UK. Yeah, it's there. It's a reality. It's not kind of a theoretical concept that I describe here. It's happening, and in particular in the pharma area.
Yeah. So you can get an injunction outside of the 18 countries to extend to 39 countries. So that's something that if you're a patent owner, you need to have that feather in your cap and know it exists. And you're probably, like me, going to want to wrap your head around it some more, and you can follow up with Tobias after this. But that's, I think, shockingly good for patent owners. It probably is shockingly bad for alleged infringers, and probably also why you're seeing the UPC drive settlements.
Absolutely, but the same holds true for the national courts. And just a few weeks ago, we have seen such a case from the regional court Munich 1, yeah, and handing down in a PI case an injunction for over 20 countries. So that's the new reality, and that's a really, I personally think, apart from the UPC, that changed my professional life because I just started over 2.5 years ago. Yeah. And also I think this decision of the Court of Justice of the European Union is definitely the most important ruling of that court in the world of patents and IP.
Yeah. So, and again, we've spent a lot of time over the last couple of days talking about how things in the U.S. seem to be getting away from patent owners, little by little, drip by drip, in a lot of different places. That's not what is happening in Europe at the moment. There's pockets of resistance, you might say, but the European Union and certainly the members of the UPC seem to be all in on protecting innovators' innovation patents, correct?
Yeah, so that's, again, of course, only my private view. The UPC definitely is attractive for patentees, but there's also some balance in the system. I need to pour water into this patentee-friendly court wine in a moment. When I look at the Court of Justice for the European Union, apart from that BSH Electrolux decision, that we saw a lot of IP-friendly decisions, yeah, and so far it's a mixed bag. But the UPC definitely protects innovation. I think when I talk to the UPC judges, that's also their mindset, to be crystal clear. And now the water into the UPC wine is, where's the balance in the system? The balance in the system is there are potentially numerous invalidity attacks, numerous bites at the invalidity apple for the defendant, yeah. And why? Because we have this counterclaim for invalidity, but we also have a standalone invalidity action, what we call always invalidity revocation before the UPC. Of course, not the defendant, which is the counterclaimant for invalidity, can also in addition file such a standalone action. There would be lispendants, but another group entity of the defendant could do. That is now already established case law. In addition thereto, we have EPO opposition proceedings, which go in parallel. These are just independent invalidity tracks. Yeah? The stay between those two invalidity tracks does not happen, only in rare exceptions. And then if we have such a European bundle patent, you could also attack that before the national courts. That means in extreme scenarios, you could imagine that there are 4 nullity attacks. That creates uncertainty. And think about these auxiliary requests that are oftentimes so decisive. Then you will have different sets of auxiliary requests in the proceedings that creates a mess, to be clear. Yeah. So that's a difficult defense for the patentee when it comes to invalidity. And here is clearly the balance in the system.
Yeah, so it's not just the panacea. It's a panacea from the U.S. perspective because you have a chance as a patent owner. But the statistics for share, could you share the statistics, for example, like on the nullity rates? What are we?
So we reviewed all published decisions on the merits, and in the PI cases, court of first instance, that were handed down by August 31st. So that means 2 years and a few months after the UPC came into existence. And what is the statistical data now? And the data is claimants were successful before the court of first instance in proceedings on the merits in 51% of the cases. So 51% means they got the injunction. And when you look at preliminary injunctions, it was even 55%. Okay, now you have to kind of evaluate the statistic, and you have to see, in addition thereto comes the settlement that we saw. Yeah, so the settlements, of course, no one knows the outcome, but you can, I think, assume that in several cases the patentee went home with some money. Yeah, maybe not in all, but in some. And that is a success rate, which of course could be changed by the Court of Appeal if these cases go to appeal. But that's also something, because the injunction is there, is enforceable without a bond requirement. I think less than 50% of the cases will go to appeal because the settlement pressure is simply too high. Then, of course, the success rate statistic needs to be watered down by cases pending in parallel before the European Patent Office, the EPO, of course. If they invalidate, one bullet kills. It doesn't matter whether the UPC upholds a patent and the EPO later on invalidates it, then the EPO has the final say, and vice versa. Yeah? And so that means success statistics over 50%, court of first instance, but that's still, compared to national litigation, a very remarkable success statistic. And now the invalidity statistics, both for the counterclaim for invalidity and this central invalidity revocation action, combined rates are close to 30% of the patents were upheld as granted, 30% upheld in amended form, and 30% revoked in their entirety. That's compared to the German system and the European Patent Office, a patentee-friendly statistic.
So I know we're kind of winding down here, but since this is a life sciences event and we have a lot of life sciences attorneys and in-house folks here today, what are the particularly relevant UPC case law that has developed in this particular sector?
Yeah, first of all, we will see very soon a decision regarding a formulation patent issued by the local division in Munich. That is to be announced soon. And we have seen a decision on infringement of a second medical use patent. And here the test is different from the US. Yeah? So no active inducement is necessary by the alleged infringer. It's just a situation where you need to look whether the alleged infringer acted in a way which leads or could lead to this therapeutical use, which is protected by the second medical use claim. and the alleged infringer knew or should have known. And so you see that's a vague test, and it's a case-by-case assessment. Yeah, but that's an important decision. And then we have the situation that is comparable to your ANDA litigation. What is now about the generic market entry, and we work with the concept of imminent infringement. What does that mean? That means that the generic company has completed all steps for the market entry, so kind of that they have the gun in their hand to pull the trigger. And if you have such a situation, then you have imminent infringement. Imminent infringement means the infringement has not yet occurred, but it's just a matter of time or a matter of the will of the generic company that it occurs. Yeah, and there we have case law now from the Court of Appeals, and so far these are kind of the milestone cases we have. But again, many are pending and in all possible scenarios. So we have a clearer picture within, I would say, the next 6 months.
These are important things for people to know. I mean, if you're having a 51% success rate in litigation as a patent owner, that's something we in the U.S. need to know. If you can get an injunction in the UPC and apply it to 39 European countries, that's something we need to know. And if only if 40% of the patents are upheld in the nullity challenges as granted, I mean, these are all good facts. It's not to say that you got to have your eyes wide open and know that you may be a statistic on the other side. But the UPC judges are willing to accept the patent owner's position. And I also think in Germany, this is the case a lot of times, and in the UPC, a case maybe even more often, where the judges have their eyes wide open and know the games that are being played by the defendants. Not all defendants are bad people or playing games, but there are some who do. In your space as well as other spaces. And the judges of the UPC see through that, it seems, with particular interest. They can see through that and know what's really going on. My perception. Would you agree with that?
I would totally agree in the sense that they are really best-in-class judges. We haven't heard on social media any criticism on the quality of the UPC decision. There is no outcry, oh, what is this? No, everyone accepts the rulings, and I think, that's remarkable.
Yeah, they're not going to rule that a drive shaft is a law of nature. Sherry, did you have a question?
Yeah, so 2 questions. So first of all, how is the enforcement done? And that was asked many times, in particular in the context of this decision now that a ruling can cover 39 states. And you say, wow, enforcement must be a nightmare. But you have to distinguish. Injunctive relief, claims for recall are just enforced before the UPC. Yeah? You go to the UPC and say, the defendant is in contempt of court, is violating your decision by continuing to offer for sale in the UK. And then what happens? A penalty payment is imposed by the UPC on the defendant that is in contempt of court. And these penalty payments are really high per product, per day. The UPC injunction has teeth. And again, the enforcement becomes only an issue when we are talking about monetary relief, because then it depends where is your defendant domiciled. But only if the judgment does not rule that the defendants are jointly and severally be liable. Then each of the defendants is liable for the whole amount of these joint debtors group. And so far, enforcement just plays only a minor importance. So it can be enforced, and that was your first part of the question. I hope I answered it. The second part was the interplay between the UK and the UPC. So first of all, I would say currently there are emotions. You read about judicial imperialism, and we have in the field of SEPs anti-suit injunctions now. It's going a bit wild there. But the UK, it's my at least personal view, the UK courts try to be competitive, and maybe that changes a little bit the picture, of course, and that's, in the UK proceedings, the role of the expert is super important. At the UPC, experts are becoming more and more important. That's crystal clear, in particular in the field of pharma and life sciences. And also what we see, because of Brexit, still the two venues respect each other, but there is of course no binding effect, and they are happy to deviate. In the case that I quoted from the Regional Court Munich that issued the injunction for over 20 countries, the UK court just said there is no infringement, so it just took an opposite position in the Regional Court Munich. So I would say maybe there is a change, but that future will tell.
Well, great. And we're going to have to leave it here, but there's more that will be said. We are following this, and thanks to Tobias, we're staying on top of it as much as anybody can here in the U.S. So stay tuned for his next article. I'll have him back in probably 6 months again for another update as well. So thank you so much, Tobias. That was wonderful.
Thank you, Gene, for your kind words.